When we think about legal arguments, we picture these intense courtroom dramas, right? But here's the thing. The tools lawyers use aren't just for lawyers. They're really just powerful tools for critical thinking and persuasion, and they can give you a serious edge in pretty much any situation.
I mean, we've all been there. You're in a debate, maybe a work meeting, and you're struggling to get your point across. You feel like you're losing the argument even when you know you're right. It is so frustrating. But what if you had a secret toolkit for seeing arguments more clearly and making your case way more powerfully? Well, that's exactly what we're going to do. We are opening up the lawyer's playbook and handing you the strategies they use to analyze, persuade, and, to win. And look, these aren't just sneaky legal tricks. They are fundamental principles of just thinking better. So first up, one of the most powerful and honestly most overlooked parts of any argument: procedure. See, lawyers get this. They know that how an argument is set up can be way more important than what the argument is even about. It's all about controlling the rules of the game before it even starts.
Get this. During the Paris peace talks to end the Vietnam War, the different sides spent weeks, just arguing over the shape of the negotiating table. Seriously, it sounds crazy, but it wasn't about furniture. It was all about power, about status, about procedure. They were fighting for an advantage before a single word about peace was even on the table. So what this all boils down to is that before you can even get to the facts, you have to get through this procedural gauntlet. It really comes down to three huge questions. Are you even on the right battlefield? Are you the right person to be fighting? And what is this fight actually about? All right, let's break this down, starting with jurisdiction. This is all about choosing your battleground. So, after the horrific Bhopal chemical disaster in India, a massive legal fight erupted. The question was, should the case against Union Carbide be heard in the US or in India? That choice of court had billion-dollar implications and completely changed the entire outcome.
Next up, you need what's called standing. It's not enough to just really care about something. In this famous case, Sierra Club versus Morton, the environmental group tried to stop Disney from building a ski resort. But the Supreme Court basically said, nope, you don't have standing, because you can't prove your members were personally and directly harmed. The lesson? You've got to have skin in the game.
And here is maybe the most clever procedural weapon of all: framing. When the chemical industry was facing new regulations on flame-retardant chemicals, they didn't argue about safety data. No. Instead, they completely reframed the debate as a civil rights issue, arguing that restricting the chemicals would hurt minority communities who face higher fire risks. Just like that, the entire conversation changed. Okay, so you've won the procedural battle. You're in the game. Now the fight moves to the words themselves. Because once you're playing, the ability to interpret text, whether it's a contract, a company memo, or a law, that becomes your superpower.
And there are two main ways to do this. Plain meaning sounds simple, right? Just read the words. But words are so tricky. There's a classic case where a contract used the word inflammable, which both sides thought meant not flammable. Whoops. On the other side, you have original intent, which tries to figure out what the authors were thinking. But with something like the U.S. Constitution, does the right to bear arms mean the muskets the founders knew, or does it mean modern weapons? That's a huge, ongoing debate.
Now, when it comes to contracts, there is one rule you absolutely have to know. It's called the four corners rule, and it basically means that judges will almost always only look at the words written on the page, inside the four corners of the document. All those side conversations, those verbal promises you made, they usually don't count. The bottom line is you have to read what you sign.
Lawyers are also total masters at finding loopholes in the language. They know that if a rule is ambiguous, it's usually interpreted against the person who wrote it, which is a great tip, by the way. They also know that being really specific can create an opening. So if a park rule says no cars, a lawyer might argue, well, it doesn't say no trucks. Or if a contract allows boats on a lake but doesn't mention kayaks, another lawyer could argue that kayaks are excluded simply because they weren't on the list. Precision is everything.
All right, we've set the stage, we've decoded the language. Now it's time to actually build your case using the raw materials of any argument, the facts and past decisions, or what lawyers call precedent.
Precedent is the absolute bedrock of the legal system. The best way to think of it is as a roadmap of past decisions. Lawyers love precedent because it gives them consistency and predictability. It shows you what arguments have worked before and what the core principles are in any given fight.
But what about the facts of your case? Well, here's the secret. Not all facts are created equal. Lawyers are trained to focus only on what they call salient facts, the ones that are legally relevant. So for example, if a giant corporation sues a small business owner, the owner's lawyer might try to paint this emotional David and Goliath picture. But that power imbalance, it isn't legally relevant to whether the contract was actually broken.
And maybe the most critical piece of the puzzle is causation. You have to connect the dots. Imagine you have a video of someone pulling a trigger and then another person falling to the ground. That seems open and shut, right? But not so fast. A lawyer still has to prove that the gunshot was the direct cause of death and not some other crazy intervening factor. Proving the why is everything.
Finally, let's arm ourselves with a logical self-defense kit. Because let's be honest, arguments aren't always built on solid ground. A lot of the time, people use rhetorical tricks and logical fallacies that sound super persuasive but are actually kind of empty. Here's how to spot them.
First up is the non sequitur, which is just a fancy Latin way of saying it does not follow. This is any argument where the conclusion has basically no logical connection to the evidence that came before it.
And the most famous example in legal history has to be Johnny Cochran's line from the O.J. Simpson trial. If it doesn't fit, you must acquit. Think about it. Just because the glove didn't seem to fit doesn't logically prove that Simpson was innocent. There could be a million other explanations, but wow, is it powerful. It's a brilliant example of a persuasive argument that isn't actually logically sound.
Oh, you see ad hominem attacks everywhere, especially online. It's that classic move of attacking the person instead of actually engaging with their idea. But there is a little nuance here. Sometimes a person's character is relevant. If you can show that someone has a bias or a history of lying that affects their credibility, well, then it can be fair game.
This one is huge. It is so easy to see two things happening at the same time and just assume one causes the other. The classic example is that ice cream sales and crime rates both go up in the summer. But eating a pint of ice cream doesn't turn you into a criminal. The hidden factor, of course, is the hot weather. You always have to look for the real cause.
So as you start using these tools or defending against them, it all kind of comes down to this core legal idea, the reasonable person. In the law, actions are constantly judged against this benchmark. Was the person acting reasonably in that situation? It's not about being perfect, it's about having a standard of sensible, responsible behavior.
And that brings us to the big final question. We've just gone through this powerful arsenal of tools for persuasion and argument, but what are they ultimately for? Are they just weapons to win at all costs? Or are they instruments that can help us get a little bit closer to the truth?
You know, the greatest lawyers and the greatest thinkers have always understood that while strategy is crucial, the most powerful arguments are always built on a foundation of sincerity and truth. You can use these tools to manipulate people, sure. Or you can use them to bring clarity, to expose flaws, and to build a much stronger case for what you truly believe in. The choice, as always, is yours. Argue with purpose.